Court calls case People versus, is it Darius Johnson?
Before we even get into the names being called, understand what kind of courtroom this is. This is not a trial day. This is not a verdict day. This is the quiet machinery of the justice system grinding forward. Bond decisions, adjournments, violations, and credibility being weighed in real time. These are the moments where people don't get headlines, but they get consequences. Today we're watching multiple defendants cycle through the same courtroom, under the same judge, but with very different stakes. One misstep here doesn't just delay a case, it can change someone's freedom overnight. Watch how Judge Simpson runs this room. The tone shifts quickly from procedural to personal. Humor slips in, but it never overrides authority. And for defendants, especially those on bond, every answer matters. Travel requests, alcohol monitoring, any refusal to appear. These are not side issues, they're tests. Tests of compliance, credibility, and control. As this hearing unfolds, pay attention to who owns their situation and who is barely hanging on. Because in this courtroom, patience exists, but it has a limit.
Yes, Your Honor. Brandon Bird on behalf of Darius Johnson for case. The case ending in 5312.
In the case ending in what? Oh, 5312. Gotcha.
Excuse me, Brian Rowley on behalf of Mr. Johnson in case ending in 1734, Judge.
Here you go. All right. What are we doing? You're requesting an adjournment?
Yes, please, Judge, for additional plea discussions. Both, but
Probable cause conference, I will adjourn to February 5th, 2026, 9 a.m. In both matters, bond will continue.
That was January 20,
No, I gave you February 5th.
February
You want the
5th.
29th? I mean, I can give that to you.
Oh, February 5th is all right.
Well, you're trying to cause me a problem, aren't you?
Sometimes my ears, yeah.
All right, thank you. Bond will continue.
can we address one issue of bond, Judge? Real quick.
Sure.
Mr. Johnson is hoping to travel to Texas, the
Why?
Dallas area, for a family matter, from January 10th through the 18th.
January 10th to the 18th in Texas.
Correct.
What part?
Dallas.
Dallas? That's where the Cowboys are.
Yeah, but they're not playing football anymore. Judge.
I know, and I don't like.
He doesn't either, Your Honor.
You don't?
Lions fan.
You're a Lions fan? Okay, that'll work. Maybe I'll let him go. Oh, you fill out a form for me.
I'm doing it.
All right, I will. He can go to Texas. Those include your travel days, the 10th through the 18th. Yeah. All right.
This exchange might feel lighthearted, but make no mistake, bond travel permissions are serious business. When someone is on bond, their freedom to move is not a right, it's a privilege. The court must balance family needs against flight risk and supervision integrity. Here, Judge Simpson probes just enough. Destination, dates, purpose, before granting permission. The joking about football teams is intentional. Judges often use humor to assess demeanor. Is the defendant relaxed but respectful, or careless? The fact that travel is granted tells us the court believes this defendant will come back. That belief is everything, because if he doesn't, the consequences ripple outward. Bond forfeiture, warrants, new charges. Notice also the clarity. Dates explicitly include travel days. That eliminates loopholes. Our courts don't leave room for misunderstandings. This is how judicial discretion works when trust still exists. But trust is fragile. One missed check-in, one unexplained delay, and that permission becomes evidence against you. Audience question: should courts be more strict with bond travel? Or is this exactly how discretion should be used?
You can go to Texas, 10th through the 18th. Sure. All right.
All right.
Thank you. I don't.
All right.
I've already put him there. Off my back. Court calls case People of the State of Michigan versus Kevin Jones.
And on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Kevin Jones. Mr. Jones, can you please state your full name for the record?
Kevin Jones.
I'd like to set this matter for exam, Your Honor.
For exam.
please.
All right, your discovery is complete.
As far as I know, Your Honor.
People have their witnesses available the 20th.
We'll do our best, Joe.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you, sir.
All right.
Here we see the machine resetting again. Preliminary examinations are not trials. They are threshold tests. The question isn't guilt. It's whether probable cause exists to move forward. By scheduling it in person and continuing bond, the court signals procedural confidence. Discovery is complete, witnesses are anticipated, and the case is moving. But don't overlook what's unsaid. When bond continues again, it reinforces a pattern. Compliance so far matters. Judges don't reward chaos. They reward predictability. This defendant is still standing in good enough stead to remain free while the case advances. That can change fast at the exam stage, where testimony locks narratives into the record. For defense counsel, this is the last controlled environment before things get adversarial. For defendants, it's the calm before confrontation. Viewer question: do you think most defendants truly understand how pivotal a preliminary exam is? Or do they underestimate it because it's not a trial?
What calls the case, the people versus Anastasia Riggs.
Andrew Toole is appearing on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Anastasia Rakes. Ms. Rakes, can you please state your full name for the record?
Anastasia Rakes.
All right, first of all, Your Honor, we tried to take a plea last time and it didn't go over so well, but I did get a chance to go over the video with my client, go over the plea, and I believe she's ready to plea now. Now, I believe we have another matter that we have to discuss about the bond violation in which my client has a warrant. And whenever you want me
She does. Let's deal with the bond violation, because I may not be taking a plea today.
Got you. Okay, first of all, Your Honor, my client indicates to us that she wasn't drinking.
She what?
She wasn't drinking. And honestly, I don't say this about everybody, but I do believe my client at this point. First of all, the blood alcohol level was 0.04. It was 0.04. If my client would have been drinking, especially with the problem that she has, it would have been way over 0.04. It was only for that one day. If you notice that she went.
If she had been drinking, it would have been over that amount?
It would have been over that amount because my client doesn't know how to stop drinking. And
Okay.
she understands that she has a problem. That's just one thing. But if you notice that she went through Christmas, she went through New Year's, and I believe Thanksgiving, you had zeros all the way across the board. And if you remember this case, my client's the one that actually said, I don't want the breathalyzer because the breathalyzer is too easy to cheat, and put herself on this alcohol tether to show the court that she couldn't that she wouldn't drink. She indicates to me that she is a clean. She's obsessed with cleaning, and it is possible that those chemicals got to her tether. But in all honesty, Your Honor, dealing with the facts of the situation that we got in front of us, we got somebody that asked to be on a stricter, to be on something stricter, to show the courts that she wasn't drink, to address her problem, even more, to make sure that she's not cheating the court. We got somebody that has dealt with alcoholism for a long time in life. And like I said, when she does drink, she drinks a lot. And she understands that. And she's looking for help. She's searching for help. She showed the court that she's searching for help. So when she does drink, she drinks a lot. And the fact of the matter is, that's why that 0.04 doesn't. I can understand when she told me that I'm not drinking. I'm not drinking. I wouldn't have put my kid in that situation. I'm all he has at this point. And she's been responsible. She showed her response. She showed she's been responsible. Like you told one of my clients, the most major drinking holiday days that then came with Thanksgiving, the day after Thanksgiving, New Year's Eve. She showed that it's been nothing. It's been nothing in her system. So I do believe it was an honest mistake, and I do believe that my client can't just drink one beer, and I honestly believe that. So, Your Honor, we're just asking that you give my client that you give my client a chance. She showed you that she could go without drinking. I believe that violation. When was that violation, Your Honor? November or December 13th?
December 17th
December 17th.
into the 18th.
But if you notice the alcohol level was dropping when it went into the 18th. So it went to 0.04 and it went lower. It went lower and lower each time. So it's not like she was continuing drinking.
Which cuts against the fact of thinking that it's a chemical. Because a chemical that wouldn't happen.
I'm
It
not.
would either remain or it would dissipate faster than the body would be absorbing any alcohol.
And that's why she didn't say she knew it was a chemical. She said that could be a possibility. But one thing she said, I know I wasn't drinking. I know I wasn't drinking. And for the fact of the matter, everything surrounding this situation, I believe she wasn't drinking. Now, even if we were to take that not to be true, what she said to me, I do believe we have a lot of mitigating circumstances to allow my client to stand out of jail. But I'm standing in front of you today that's saying that I really believe my client when she said she wasn't drinking. I seen the video of when she drinks. I heard the discussion. I heard the discussion that the witnesses had with the police that talks about when she drinks and how much she drinks that she just can't stop. So a 0.04, I can't see my client taking a sip of anything and stopping. I can't.
Response from the people.
I would leave it up to your Honor's discretion, these sorts of things, as I always do. Like 0.04 to me is not nothing.
Right. How long has she been on the tether?
For about 2 months, maybe 2 months.
Pardon?
Yes, I've been on it like a month, 2 months.
And as I stated earlier, Yana, she's the one that was taking the breathalyzer and came in here and asked to be on the tether instead of the breathalyzer to ensure that she doesn't think
Here's what I'm gonna do. You want this adjourned, right?
the bond violation. We were gonna say,
Go ahead, what?
we'd like it dismissed, but if we can adjourn it, Your Honor, then yes, please. We would like it adjourned, but I do know my client is ready to proceed with the plea, but if you're not at that point, then
I'm not at that point yet. I mean, I'm not saying that I won't, but here's what I'm gonna do. I'm gonna adjourn the probable cause and the bond violation. I'm gonna adjourn it out to February 12th, 2026, 9 a.m. And I'm just gonna say it this way. What I really of right should do is I should put you in today. I'm not gonna do that.
This is the most dangerous sentence in the entire hearing. When a judge says, I should put you in today, that's not rhetoric. That's authority being restrained. Judge Simpson makes it clear this decision goes against his normal practice. That matters. Judicial consistency is a cornerstone of fairness, and when a judge deviates, it's memorable. The deal is explicit. Any further issue equals 60 days. No explanations, no chemical theories, no mitigation. This is conditional mercy, and it comes with absolute clarity. The court is drawing a hard line. From a legal standpoint, this is smart. It creates notice. It removes ambiguity. If incarceration happens later, the record will show it was warned, explained, and agreed to. For the defendant, this is a last exit before custody. For viewers, this is raw judicial discretion on display, restraint paired with consequence. Question: do you think judges should give one last chance like this? Or does it delay accountability?
Mr. Byrd has convinced me not to do it. That is something that is against my normal practice, but I'm
Thank you.
not gonna do it. Well, don't thank me yet. Because normally you might spend a week, 10 days, get your help, do whatever. But now we're gonna make a deal. I'm gonna adjourn this out to the 12th of February. We have any event whatsoever, I'm not listening to any of that. I'm not listening that it might be a chemical. I'm not listening that something went wrong. I'm not listening to anything. You're just gonna go in and you're gonna do 60 days. Understood?
Yes.
So we'll put it up to that date. And continue.
Thank you, Your Honor.
Yes, the warrants, so reinstate the previous one. Court does call the case, Southern People State of Michigan versus Ronald Fleming.
Good afternoon, Your Honor. Ashley Lottie Feltes for the people.
Assistant Public Defender Jay Valentine on behalf of Mr. Fleming, who is not present in person today for the record.
Yes,
And the people submitted a motion, Your Honor, all that, Ms. Lundy.
That's correct, Your Honor. The sum and substance of our motion the court has reviewed is basically to ask the court to have an iPad brought to the defendant's cell. He's refused on a number of occasions, both before and after being found competent, to come and participate in these proceedings. I know the court is very familiar that the people are entitled to a speedy resolution of the case, just as the defendant is. We are asking that the court have the iPad brought into his cell at his next PCC, advise him of his right to be present, and if he should continue to refuse to come up, to make the finding that he is voluntarily refusing and allow us to get this set for a preliminary examination and go ahead and continue on. I think defense counsel has a couple of other concerns. I'll let them place on the record, but essentially we just want to get the case moving, Your Honor.
understood.
This segment highlights a different kind of courtroom challenge, a defendant who refuses to participate. Legally, that creates tension between rights and progress. A defendant has the right to be present, but not the right to stall indefinitely. The prosecution's request is procedural, not punitive. Bring the iPad. Advise him of his rights. If he refuses, move forward anyway. Case law supports this. Courts cannot be held hostage by silence. Defense counsel's concern is practical and ethical. They haven't seen their client, can't assess competency, can't advise effectively. The court's solution balances both sides. Compel appearance via technology, create a record, and proceed if refusal continues. This protects the integrity of the process while preserving appellate safety. It's not harsh, it's necessary. A viewer question: if a defendant refuses to engage, should the system slow down or keep moving without them?
Your Honor, I would echo much of what Ms. Lundy said. I obviously want an opportunity to speak with my client as well. He's been refusing to see us for months now. In terms of what I am looking for is, I imagine that the court is going to compel him to come through at least what Ms. Feltz has suggested, through an iPad, through the cell, and that's all fine and well. I just think at this point, I don't know what he looks like. I haven't talked to, I know what he looks like. I just don't know how he appears at this point in terms of where he's at with competency. So I think this would give us a good opportunity to at least to see him, be able to evaluate him either on the record or explain to him, the consequences of not participating in preparation for his examination. It would give me an opportunity to tell him as well that we do have a social worker in our office, and I'd like an opportunity for her to start working with him. I think that would be an excellent idea in terms of getting him prepared. Otherwise, Your Honor, I would just be asking to compel for PCC in lieu of an exam at this time. I just want, again, to get an understanding of how he appears for purposes of whether
That's what I'd be doing. I'd be adjourning this out, compelling him to appear via through the tablet, apprise him of that he needs to participate basically in the proceedings, and that if he doesn't, the proceedings will go forth without him. I will let you know that in the past, when we've had this issue, and it occurred in a different way, but where we had a defendant that voluntarily or may have involuntarily decided he did not want to be present, but voluntarily, but how they did it. Then at the exam, a a tablet was placed outside their cell. The exam is conducted. They're there. I try to allow counsel an opportunity to converse with their client where it's going to be necessary, but we just proceed with the exam. So that's how I'd anticipate this proceeding, given his failure to.
Judge Simpson lays out precedent here, and that's crucial. This isn't improvisation, it's experience. Tablets outside cells, exams proceeding, counsel adapting. The court is signaling that refusal does not equal immunity. Importantly, the judge still allows counsel opportunities to communicate when necessary. That balance matters for due process. The granting of the motion, paired with a written order, protects everyone. It documents compliance with constitutional requirements while advancing the case. Notice how firm but measured the court remains. No anger, no threats, just structure. That's effective judging. It also sends a message to the defendant, even in absence. The system will move forward with or without you. Audience question: do you think remote participation protects defendants' rights or erodes the human element of justice?
To do that.
Certainly.
Thank you, Your Honor. In my review of case law, it's pretty clear that he has to be given the
No.
information, and then it should be refused, then we can move forward without it.
That's right.
So I appreciate the court doing this.
So I'll adjourn the probable cause to the 22nd at 9 or what, it will be in the 9 o'clock block. And then we'll get the first part of this done. I would need, if you would, Ms. Feltes, I'll grant your motion. So if you'd prepare a written order to that effect, so that.
I will, or I will ask a friend for help, yeah.
Okay.
And then, Your Honor, I would ask the court for future consideration, understanding that this is being set for a PCC first. I would ask the court for future consideration in setting this for an exam for a special date. I would be asking that it be set for some Friday in the future. And that's for purposes
You know
of
what judges are available on Friday?
this one.
I'll let you.
Judge Washington?
I will let you ask at under 20.
Okay, thank you.
Not sure what answer I'll give.
All right, and that's for purposes, I know Mr. Pesky wants to be involved in this. So
Ms. Novesky wants to be involved?
she wants to sit second chair.
No, that's not happening. Then I'm gonna make it as all right.
I'll give her your regard, Your Honor.
Yes. Bond will continue.
Thank you.
This hearing wraps with a familiar phrase: bond will continue, but the meaning varies across cases. Today, we saw discretion used generously, cautiously, and conditionally. Travel was allowed. Violations were tolerated once. Refusal to appear was met with structure, not delay. Judge Simpson balanced empathy with enforcement, repeatedly making clear that patience is finite. The broader lesson is simple. Courts reward accountability. When defendants engage, comply, and show effort, they earn flexibility. When they test limits, the response hardens quickly. These aren't dramatic verdicts. They're the moments that decide whether someone sleeps at home or in a cell weeks later. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.